and paragraph 16.
Yes, Your Lordship.
Can you read those paragraphs which you intend to expunge?
Your Lordship, paragraph 16 says that...
Paragraph 10.
It's the code. It's the
Your Lordship, may I take note that these paragraphs have been expunged?
We have not expunged those paragraphs. It is your application.
Expunged them. The petitioners have credible information that Honorable Mrima is a close associate to the proposed Deputy President, one Mr. Kithure Kindiki, and that the said judge failed, refused, or neglected to disclose those facts to the parties at the inception. The basis of the application to expunge that particular paragraph is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kithure Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor
You
Ojienda,
will have your time to submit, sir. Stop eating. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
in a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record.
You have the right.
Dr. Kamuna, we would appreciate if you want to address us in the course of the as in your submitting. Is that the position?
Yes, that's
okay, proceed.
My position is that if there is a party.
Are you supporting the motion?
I'm supporting my line of friends complaint to Ndegwa and Njiru as my friend is a kid.
We need to go.
Yes, there's a
Oh, yes.
I'll finish it.
Because of pregnancy myself.
Yes.
Thank you very much to my senior my lords. I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from a respondents, or should not. My Lords, my Lords and your Ladyship, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my Lords and your Ladyship to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal heard afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talukan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my Lords and your Ladyship, are you there? In the middle of paragraph 9. During the pendency of the applicant's motion and the respondent's preliminary objection, this court in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, your Ladyship and my Lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice